Okay, so by way of preparation for the Supreme Court's decision in Dobbs v. Jackson, expected in late June, I want to get into the weeds with you about Planned Parenthood versus Casey, the 1992 decision that, of course, reaffirmed Roe v. Wade and is still the law of the land today. It is not Roe, but Casey and its undue burden standard that governs abortion law. And so it is Casey that we should seek to better understand as we think together about the future of abortion rights, especially with the court now in a position to overturn Roe. But before I get into Casey, I just want to say a few words about Dobbs to get everyone up to speed in case any UVA law student or anyone else watching out there has had his or her head in the sand for the last several months. At issue in Dobbs is a 15-week ban on most abortions out of Mississippi. Because 15 weeks is well before viability, that stage when an unborn child can live with much medical assistance outside her mother's womb, the Mississippi statute has come head to head with Supreme Court jurisprudence, or more specifically, with Casey. So legal scholars on both the left and the right agree that Casey forbids laws that prohibit abortion before viability. So the law cannot both uphold the very moderate 15-week ban and also hold to Roe and Casey. In a word, the statute and case law are irreconcilable. Okay, so let me now turn to the case law. So as I'm sure you all know, Casey is an opinion that sounds in substantive due process, but was mostly decided on the basis of stare decisis. But in my view, Casey is really an opinion concerned about women's equality, but until recently, really hadn't been critiqued from that perspective. Thus, the late Justice Ginsburg was not wrong when she described Casey as such in her fiery dissent in the late-term abortion case, Gonzalez v. Carhart. Quote, as Casey comprehended, at stake in cases challenging abortion restrictions is a woman's control over her own destiny. The accuracy of Ginsburg's description of Casey aside, however, I think Casey's view of women's equality is deeply troubling, as I'll spell out tonight. My remarks tonight draw heavily from a lengthy law review article I wrote and Douglas mentioned for Symposium on the 14th Amendment and Abortion about 5 years ago. The article, published in Quinnipiac Law Review, was the basis of an amicus brief I co-authored and submitted in Dobbs on behalf of 240 women scholars and professionals and several pro-life feminist organizations. While I invite you to read the amicus brief, it's my article, and so the parts of the amicus brief that are drawn from it that I'll focus on tonight. In the article, I argue that equality reasoning for abortion can be found throughout the joint opinion in Casey. Indeed, that women's equality is really the central interpretative concept. But as I have only a brief time with you, I'm going to focus on the most consequential aspect of the Casey opinion as regards reliance interests. So by way of summary at the outset here, I will argue that Casey reaffirmed Roe not because the justices in Casey thought Roe was rightly decided as an original matter, as they tell us more than once in the opinion, but rather because the justices who wrote the joint opinion assumed that the country over the intervening 19 years had come to rely upon the right bestowed in Roe as a centerpiece of women's liberty and equality. And the justices just couldn't stand in the way, whatever the Constitution said or didn't say about the matter. So one question among the many we might ask about this sort of judicial determination is the one I'll grapple with tonight: whether our society's putative reliance on abortion has actually promoted women's equality. I think that on the whole, it has not. In doubling down on Roe during a time of rapid cultural change, Casey put the weight of the court's authority on a particularly inhumane way of trying to secure women's equal status in society. And in my view, this has debilitated efforts to more authentically respond to women's disproportionate role in reproduction ever since. So with that brief introduction, let me now offer a bit of background on Casey, how the case was decided and what led up to it, before I jump into the substance of my argument regarding women's equality. Okay, so Roe v. Wade was criticized almost universally in the legal academy after the decision was rendered in 1973. Even those in favor of abortion rights found fault with the privacy rationale in Roe, which I put up here on the screen. Most famously, pro-choice law professor John Hart Ely, who excoriated the decision the very year it was rendered in his singular commentary, The Wages of Crying Wolf. Still, I'd add, probably the single best critique of the Roe opinion, and so very much worth reading and rereading today. In the decades that followed this and other critiques, a cottage industry arose within the law journals in search of an alternative constitutional justification for the beleaguered right. With almost unanimity, that alternative was equal protection, first fully articulated in 1977 by UCLA law professor Kenneth Karnst. Karnst wrote, cases such as Eisenstadt, the contraception case the year before Roe, Roe v. Wade, and the pregnancy discrimination case Lafleur, all these can be seen as women's role cases. So they implicate the principle of equal citizenship, for they involve some of the most important aspects of a woman's independence, her control over her own destiny. The abortion question was not merely a women versus fetuses issue. It was also a feminist issue, an issue going to women's position in society in relation to men. So the Equal Protection Clause had, of course, been put to new use beginning in 1971 and in the decade that followed as the court began to strike down statutes and regulations it deemed to have arbitrarily discriminated on the basis of sex. Influential expositors of the law, most notably Ruth Bader Ginsburg, that advocate most responsible for the court's new turn on sex discrimination, latched on to Professor Karnst's equality rationale for abortion rights. With Ginsburg's influence especially, equality reasoning became the prevailing means by which legal scholars and then advocates defended the Roe regime, even if the Roe opinion itself had few defenders. It's no surprise then that nearly 20 years after Roe, when the court sought to replant the right to abortion on more solid constitutional footing in Casey, the justices had equality reasoning in mind. Now, as the nation awaited the Supreme Court's decision in Casey, many commentators suggested the High Court was poised to overturn Roe. 12 years of Republican judicial appointments had altered the High Court's composition, and in 1983, Justice Sandra Day O'Connor had already announced her disfavor of the 1973 opinion in her dissent in City of Akron v. Akron Center. So yes, the political and journalistic world has been anticipating Roe's demise for decades. And I think no doubt this has been a major cause in the growing political divisiveness in our country. But rather than overturn Roe, Casey, of course, reaffirmed Roe, but altered the test under which state regulations of abortion would be reviewed. So in an opinion signed jointly by Justices O'Connor, Kennedy, and Souter, the court held that the trimester framework Roe had erected, the strict level of scrutiny Roe had required, and the cases subsequent to Roe interpreting the same, putting the text up for you on the screen, had all, quote, too little acknowledged Roe's own express regard for the state's, quote, important and legitimate interest in potential life. The joint opinion thus inserted in places of Roe's trimester framework a revised version of the undue burden standard O'Connor had previewed in her dissent in Akron 10 years prior. So notice the language here of the undue burden standard. Clearly one exists if the substantial obstacle is, well, a complete prohibition, as we have in Dobbs. Now, curiously, the Casey court suggested at several different points in the joint opinion that even as it reaffirmed the, quote, central holding in Roe, it was not able to endorse the 1973 decision due to Roe's underappreciation of the state's, quote, profound interest in fetal life. Indeed, the joint opinion suggests at various times that as an original matter, the justices signing on to that opinion in Casey would likely have decided Roe differently. Still, even if the Casey troika or even a single justice among the three thought that Roe was wrong as a matter of constitutional law in 1973, in 1992, they reaffirmed the decision, writing that, quote, a terrible price would be paid were the court to reverse course now. The court reasoned that the potentially erroneous decision 19 years prior had created certain reliance interests in the decision, and thus the right to abortion had become, quote, a rule of law and a component of liberty we cannot now renounce. the court declared that the doctrine of stare decisis, wherein the court stands by a prior decision even if it is wrong, makes this so. Now, many have ably critiqued the court's use of stare decisis in Casey, most notably the late Justice Scalia in his Casey dissent, and eminent constitutional law professor and popular FedSoc speaker Michael Stokes Paulson. I should add that the amicus briefs of Ethics and Public Policy Center and Marian Glendon and Carter Sneed and Dobbs are also excellent on stare decisis as well. But when the plurality declared that, quote, a terrible price would be paid for overruling Roe, both Scalia and Paulson understand the court to be concerned primarily with the legitimacy and integrity of the court itself. And this basic critique of Casey's stare decisis reasoning is mainly, until very recently, what we hear from conservative legal thinkers on the whole, and what we always hear debated during judicial confirmation hearings. But I think it's pretty clear that the text of the joint opinion indicates that the court was actually primarily concerned with something else: the impact reversal would have had upon women's enhanced status in society. So by its own terms, Casey indicates that women's constitutionally protected liberty to access abortion to, quote, participate equally in the economic and social developments of the nation is the key substantive concept undergirding the controversial reaffirmation, which we're going to get to very soon here. Now, perhaps the court's concern with its own constitutional integrity and legitimacy went hand in hand with worries about how the court would have been perceived had it upended the constitutional right to abortion, what had become over the intervening 19 years the sine qua non of the modern day women's movement. My point here then is not to disturb others' critiques of stare decisis or institutional integrity. My point here is only that critics of Casey did not, for decades, take the underlying concerns about women's equality seriously enough. And so this is what my law review article and our amicus brief in Dobbs seeks to do. I want to be clear, though, that I am not suggesting that the joint opinion in Casey is at all as forthright as Justice Harry Blackmun's concurrence in Casey or Justice John Paul Stevens' separate concurrence, in which they both suggest that the court ought to alter altogether the constitutional basis for protecting abortion rights from due process to equal protection. Now, remember, Ginsburg and other scholars had, of course, argued for just this shift. But the joint opinion's use of stare decisis in Casey, in particular, its discussion of reliance interest, does nearly the same work, at least rhetorically, without abandoning the due process framework. So we need to now look at the off-coded Casey text, in which the plurality maintains that individuals and even society as a whole have reliance interest in Roe. Now, as a quick review for those not currently studying contracts, reliance interests in law are usually at play in commercial or property disputes, when a change in the terms of a contract or other legal interest would cause serious inequity to those who have relied upon it, perhaps by prior commitment of investment or something like that. During oral argument in Dobbs, Justice Kagan brought attention to the unique and novel quality of the reliance claim in Casey when she referred to it as airy, A-I-R-Y, up and against the, quote, grounded quality of reliance claims in the contract context. Okay, so let's jump to this key text that all of you, I'm sure, have undoubtedly heard many times before. For 2 decades of economic and social developments, people have organized intimate relationships and made choices that define their views of themselves and their places in society in reliance on the availability of abortion in the event that contraception should fail. The ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. Now, there are 2 claims being made here. One as regards the interplay of abortion and contraception, the other as regards women's equal participation in economic and social life. Obviously, these 2 are themselves interconnected, but I'm going to look at each in turn to ask whether reliance upon the right bestowed in Roe was as good for women's equality as Casey presumes. Now, as a descriptive account, I think the first, concerning intimate relationships, is quite accurate. Again, from 1973 onward, many people have organized intimate relationships and made choices that define their views of themselves in reliance on the availability of abortion in the event that contraception should fail. This sounds like an apt description of the sexual revolution. And so at first glance, the relationship between contraception and abortion seems straightforward. No contraceptive method is foolproof. Therefore, for women to, quote, control their reproductive lives, abortion must be readily available as a backup. And yet the truth is not so simple. Reliance upon abortion is very much at work in contexts where abortion is readily available, as it had been made in Roe. But the reliance effect of readily available abortion, if studied over time, is more far-reaching and deleterious than the court here presumes. Indeed, reliance upon abortion is less notable, in fact, as a remedy for contraceptive failure in individual cases. Rather, easy abortion access, as had been granted in Roe, is far more notable, according to economists, for its moral hazard effect, for inspiring a large-scale societal-wide increase in sexual risk-taking on the part of sexual actors. That is, rather than merely offering sexual actors a practical fail-safe in the event of a contraceptive failure, as the Casey court kind of naively assumes, easy abortion access has actually been shown to disincentivize contraceptive use and thus lead to more abortions overall, as we especially saw in the 1970s and 80s. Dr. Alan Guttmacher, then president of Planned Parenthood, which was still a pro-contraception, anti-abortion outfit, was prescient in this regard when in 1968 he said, "When an abortion is easily obtainable, contraception is neither actively nor diligently used." So let's look at this moral hazard effect a bit more closely. As Wellesley College economist Philip Levine explains in his book, Sex and Consequences, quote, "The problem with the view that abortion impacts only the individual or the couple is that abortion decisions may also lead to something that economists call an externality, in which the behavior of one individual has implications for the well-being of others. And that externality may be positive or negative for society." So how does easy access to abortion produce this externality? Well, as analogized to insurance, abortion offers complete protection against the risk of childbearing. But complete protection against risk, economists tell us, tends to lead to riskier behavior. Relatively easy access to abortion, then working as a kind of secondary insurance to the primary insurance of contraception, has been shown to change sexual actors' behavior in favor of greater sexual risk-taking, thus increasing, quote, the likelihood of abortion being needed. Here's Richard Posner in 1994 describing the sort of unintended consequences here. "If abortion is cheap, intercourse will be more frequent and may generate more unwanted pregnancies, not all of which will be aborted. This should help us to understand the combination of cheap contraceptives, frequent abortions, and yet a high rate of unwanted births in our society." And this makes good sense of the data on abortion rates over the decades. In the period just after Roe, when abortion was made readily available, abortion rates spiked. And not only because women could access overnight a procedure that had been more or less legally prohibited. Rather, with abortion available as a backstop to contraception, individuals engaged in more sexual risk-taking. And lo and behold, more risk-taking resulted in more children conceived and increasingly outside of marriage. And so after Roe, greater numbers of women aborted, but the non-marital birth rate exploded too. For not all women are willing to end the lives of their nascent children. And the rate of non-marital births has increased most significantly over the last half century among poor women, for whom the attitudinal decoupling of sex and childbearing and marriage ushered in by this new sexual insurance scheme has been most acute. This does not sound as though women on the whole are having a much easier time, quote, controlling their reproductive lives. Now, were abortion less readily accessible or more, quote, costly, economists suggest that contraceptive use and greater avoidance of sexual intercourse would increase, and that the rate of unintended pregnancy, abortion, and even single motherhood would likely decrease, though of course never to a vanishing point. These economic theories detailed over the last couple of decades, I put some of the findings up on the screen for you, seem perhaps to be playing out in our day. Recent data has shown a significant increase in the abortion rate beginning in the early 1990s. Excuse me. Recent data has shown a significant decrease in the abortion rate beginning in the early 1990s. Pro-lifers have credited legislative restrictions to abortion at the state level in the decades following Casey. Pro-choicers have credited increased contraceptive use. Well, perhaps both are true. Modest restrictions on abortion have made abortion a bit more costly and therefore have created incentives toward more responsible sexual activity, including more contraceptive use and greater avoidance of sexual intercourse, both of which have been reported recently. As University of Pennsylvania economist Jonathan Click summarized the econometric studies on abortion policy and sexual behavior, quote, individuals, even young individuals whose sexual behavior is often considered to be driven more by emotion than by calculation, are sensitive to the costs of sexual activity. When those costs increase, individuals engage in less risky sex. So the descriptively accurate account of reliance upon abortion in intimate relationships is entirely question-begging as a prescriptive matter. That is, could such a, quote, reordering of thinking around abortion, such reliance upon abortion, have actually had a distortive, detrimental effect upon society, upon women? One could argue that in practice, the sexual insurance policy putatively taken out in Roe to insure both sexes, in reality ensures only, or primarily at least, men, leaving women, especially poor women, worse off. Not only did sexual norms shift away from the higher commitment sex that research continues to indicate is preferred by most women, but the increased rates of unexpected pregnancy, non-marital births, and abortion that accompanied the sexual ethic promoted by Roe disproportionately impact women, not men. So is this equality or something else? We'll return to this point a bit later. Now, of course, the court was not only interested in how people have organized intimate relationships, the court was also concerned with people's places in society, and in particular, the place of women in society. Again, the ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. The court cites its authority for this proposition, both a page and a footnote, from a book entitled Abortion and Women's Choice, published in 1990 by Professor Rosalind Pollock-Bachiochi. The page of the book referenced by the Casey Court falls in a chapter that discusses the correlation between women's decreased rates of fertility with women's increased rates of education and employment, especially in the decades prior to Roe, during and after the Second World War. Such a correlation is unsurprising and uncontroversial, and the author is good to point out that the causal relationship between the two is uncertain. That is, do women tend to work more when they have fewer children, or do women tend to have fewer children when they work more? But notice here, the Casey Court is not simply making a claim about women's decreased rates of fertility. It is making a claim specifically about abortion. That is, in declaring in a case concerning abortion that women's participation in social and economic life is, quote, facilitated by their ability to control their reproductive lives, the court is making the much more specific claim that abortion is necessary for such participation. But Bachiochi does not say this. Instead, she hypothesizes, notes the complexity of the data she is discussing, and even that the data is not subject to generalization. But generalize is exactly what the court does. And so in grounding its reaffirmation of a decision it thinks was likely wrongly decided as an original matter, the Casey Court is relying on a generalization unsupported by the very reference it cites. That is, even if lower fertility rates do lead to higher rates of education and employment or vice versa, the court does not offer any evidence that abortion, rather than, for instance, fertility regulation of various kinds, is specifically correlated with higher rates of education and employment. To date, we still have no such evidence, despite anecdotal accounts in recent amicus briefs proclaiming things like, I'm an attorney because I had an abortion. In fact, as abortion rates have fallen precipitously in recent decades, women's extraordinary gains have continued apace. Former Chief Justice Rehnquist thankfully called the court out in this regard in his Casey dissent. Surely it is dubious, he says, to suggest that women have reached their, quote, places in society in reliance upon Roe, rather than as a result of their determination to obtain higher education and compete with men in the job market, and of society's increasing recognition of their ability to fill positions that were previously thought to be reserved only for men. One can point more readily to both state and congressional initiatives in support of women's equal opportunity in the workplace, as well as the many anti-discrimination cases won by the High Court since the 1970s. Dubious, yes, Justice Rehnquist, and a bit insulting too. After all, putting aside the court's lack of evidence for its broad claim, and even assuming, just for the sake of argument, that women's equal participation in economic and social life is an appropriate proxy for gender equality, an assumption I would dispute, the joint opinion's further assumption that abortion is necessary for such equality could be construed instead as deeply misogynist. After all, as I argue in an article for the Harvard Journal of Law and Public Policy, the equality argument for abortion rights rests on a peculiar 1970s feminist philosophy that reduces sexual equality to sameness, setting up the male body as the norm. As many now know, this disembodied theory of equality marked a dramatic departure from prior generations of women's rights advocates, Mary Wollstonecraft in the late 18th century, and the 19th century suffragists, no less, who instead insisted that women's unique capacity to bear children did not undermine their fundamental equality with men. I want to pause here on the slide of Victoria Woodhill. She's the first woman to run for president, to testify before Congress. And she says some really striking things. Please note, 2 years after the ratification of the 14th Amendment. She says the rights of children, that is, individuals, begin while yet they remain the fetus. And she talks about how it is much a murder to destroy life in its embryonic condition as it is to destroy it after the fully developed form is attained. For it is the self-same life that is taken. And I also invite you to go look up Victoria Woodhill. She's not a Christian. She was a free love advocate, a big advocate of divorce, in fact. And she also was, I think, the first woman stockbroker and had her own newspaper. She was a radical and very much an advocate for women's constitutional equality, but also very much against abortion. For the suffragists, abortion was evidence of women's ongoing oppression. And many, like Elizabeth Cady Stanton, presumed the repugnant practice would be abolished by the elevation, education, and enfranchisement of women. The women's rights advocates of the late 19th century fought for suffrage in part to enable women the political means to work toward a more humane society that would be more hospitable to both women and vulnerable children, both born and, as they say, those still developing in their mother's wombs. Indeed, it was not until the 1970s that agitating for abortion rights would take center stage in women's rights advocacy. When Betty Friedan and Pauli Murray first penned the original statement of purpose for the National Organization for Women in 1966, it did not include abortion at all. Rather, that still revolutionary statement was able to articulate a vision of women's equality without recourse to abortion, calling for the country to, quote, innovate new social institutions which will enable women to enjoy the true equality of opportunity and responsibility in society without conflict with their responsibilities as mothers. It urged not only robust anti-discrimination law, which would come to pass, but also better recognition of the, quote, economic and social value of homemaking and childcare, which would not. The following year now changed course, and in 1968 included abortion rights in its 8-point National Women's Rights Program. Abortion has, of course, remained the sine qua non of the movement ever since. The equality argument for abortion suggests that just as men can physiologically avoid the reproductive potential of sexual intercourse, men's bodies, after all, do not experience the consequences of their fertility within them, so too should women be enabled. As eminent law professor Lawrence Tribe writes, quote, while men retain the right to sexual and reproductive autonomy, restrictions on abortion deny that autonomy to women. But it is not abortion restrictions that deny sexual and reproductive autonomy to women. The state of pregnancy itself exhibits the embodied reality that when pregnant, a woman is not physically autonomous. She is carrying a new, albeit dependent and vulnerable human being within her. Thus, unlike a man who has fathered a child, a pregnant woman cannot simply walk away. No, to approach the desired autonomy of the child-abandoning man, a pregnant woman must engage in a life-destroying act. Sexual equality is sought then not by demanding that men meet women at a high standard of reciprocity mutual responsibility and care, as Wollstonecraft and the 19th century women's rights advocates had argued. Rather, as men had wielded the common law right of dominion over their wives, women would now seek a similar right to the ultimate sort of dominion over their unborn children. Relying on abortion to, quote, facilitate sexual equality then is seeking a kind of faux equality for women by way of imitation of men, and not very good men, I might add. Instead of insisting upon cultural acceptance of the distinctive reproductive capacity of women and cultural respect and support for the caregiving women still disproportionately undertake, abortion rights feminism seeks to facilitate sexual equality through legitimating violence against nascent dependent children to whom their mothers and their fathers and society at large properly owe duties of care. Indeed, the Casey plurality offers no argument that abortion is an act worth relying upon for the good of women's equality. As in its contraception discussion, it merely assumes so. But given the violent nature of the abortion procedure committed against an innocent, albeit nascent child, that assumption on the part of the plurality is reminiscent of the sort made of prior social evils that our nation also relied upon for positive social goods. That is, the very idea of relying on abortion for women's equality would seem to have a rather nefarious historical analog. When then Democratic presidential candidate Elizabeth Warren hailed abortion rights as economic rights, and both states and corporate consultants speak of the so-called business case for abortion, is not the logic eerily parallel to how Southern Democratic legislators justified slavery. Slaveholders relied on enslaving Black human beings for their economic well-being. Women workers, we are told, rely on ending the lives of their unborn children for the same. As Michael Stokes Paulson put the same point while employing the language of Casey, for 2 decades of economic and social developments in vast regions of the nation, people organized personal relationships and defined their views of themselves and their places in society in reliance on the legal regime of segregation. The same too can be said for the putative property rights the court notoriously upheld via the Due Process Clause in Dred Scott. The entire Southern economic system had relied on slavery for its economic and social developments. That they did so rely does not, in itself, speak to the reasonableness, rightness, or constitutional bearing of the Reliance claim. Justice Alito made just this point during Dobbs' oral argument concerning a societal reliance upon Plessy. As he said, it was, quote, improper reliance on an egregiously wrong understanding of what equal protection means. So just as we can say that a flourishing economy is a social good, but that relying on slaves to furnish such an economy is a great social evil, so too can we say that women's participation in economic and social life is a social good, but that endowing women with a high court license to end the lives of their unborn children is, I would argue, echoing Wollstonecraft and the suffragists, a great social evil. As Rehnquist wrote in his Casey dissent regarding the indeterminate nature of Reliance interest, the simple fact that a generation or more had grown used to these major decisions, he's referring here to Lochner and Plessy, did not prevent the court from correcting its errors in those cases, nor should it prevent us from correctly interpreting the Constitution here. Further, the same sort of critique I offer regarding the relationship between contraception and abortion is again available here. Does not society's putative reliance upon abortion for women's equality beg the very question of whether that reliance actually advances women's equality? For I think a very strong argument can be made that the constitutional right to abortion has actually hindered the authentic equality of women by promoting cultural hostility toward pregnancy and motherhood, and so derailing the necessary cultural respect and accommodation they deserve. So by way of extended conclusion here, let me flesh out this final point. The 1960s and early 70s were decades awash in new questions that emerged with the revolutionary release of the birth control pill alongside women's increased social status and the unprecedented entry of mothers of young children into the workforce. As the then distinct women's movement and sexual revolution moved apace alongside one another, but not yet together, society had before it a newly emergent set of yet unforeseen and entangled questions. Number one, how to enable women to participate more fully in the public sphere. Number two, how to manage the significant technology shock created by the advent of the pill, effective, but importantly, not 100% so. And number three, how to maintain utmost societal concern for the perennial need to care for dependent children, who heretofore had been the primary responsibility of their mothers. The Supreme Court in 1973 chose one definitive route, short-circuiting the impassioned debates going on across the country in state after state, and thereby frustrating not only a better compromise among contending perspectives. It also thwarted more humane and creative cultural responses to the asymmetries that naturally exist and socially persist because of women's disproportionate role in human reproduction. The court in 1992 then doubled down on this particular response, explicitly acknowledging that over the course of nearly 2 decades, the country and its scholars and its actors had come to rely upon abortion for women's equal participation in public life. Indeed, it may be that when the Casey court suggested that an entire generation has come of age free to assume Roe's concept of liberty in defining the capacity of women to act in society, it is again descriptively accurate. When the Casey court doubled down on the constitutional right to abortion, employers and other public institutions remained free to be unchanged by women's participation in them. Through women's legal right to abort their nascent children to participate in the market economy, women have learned to model themselves after the unencumbered men with whom they seek to compete. But what if instead, smart and talented women and men, like the ones presumably listening to me tonight, led our profit-driven culture to understand that most working persons are, or ought to be, deeply encumbered by their prior obligations to their families and to the dependent and vulnerable at large. It's no surprise, given the centrality of abortion rights in the feminist movement today, that work-family balance remains such a pressing issue facing women, and that it is women's status as mothers, not their status as women, that still causes the greatest inequities socially and professionally, despite remarkable gains to women overall. The idea that abortion rights offers a solution to that problem, or as I am arguing, have exacerbated the same, is a question ripe for serious debate within feminism itself. It is a debate that the Supreme Court has forestalled with its intemperate abortion rights jurisprudence, to the great detriment, especially of the poorest of women. Georgetown law professor Robin West, a pro-choice scholar whose work I deeply admire, has similarly suggested an inherent tension exists between the constitutional right to abortion and a legislative agenda that better values caregiving. Parenting, West insightfully writes, has merely become an expensive consumer choice. Quote, by giving pregnant women the choice to opt out of parenting by purchasing an abortion, we render parenting a market commodity. The right to an abortion gives women a right not to be a caregiver, but at the cost of rhetorically making the difficulties of caregiving all the harder to publicly share should she opt for it. For privileged women, this is not such a terrible trade-off, she says. The woman only marginally capable of supporting even herself, however, faces a choice between parenting and severe impoverishment on the one hand, and foregoing children on the other. But consider the counterfactual. Without Roe, and with Ruth Bader Ginsburg's commendable wins in sex discrimination cases in the 1970s, workplaces would have had to adjust much more quickly to encumbered women and duly encumbered men, and so to the demands of the family more generally. The legislature was designed for the sort of pull and tug that could have occurred between various feminist, business, family, and social organizations, much like what happened in Western Europe after the sexual revolution. There, as Harvard professor Marian Glendon revealed in her book, Abortion and Divorce in Western Law, Europe saw a far more limited abortion allowance with strong statements and policies in support of caregiving. Though the United States would likely extol and support caregiving differently than Western Europe has, it surely would have been a priority much sooner without the reliance on abortion the Casey court so boldly affirms. When we belittle the moral status of the unborn child, treating the nascent human being in nearly a century of Supreme Court case law as potential life, or in academic and popular arguments as something parasitic upon the pregnant woman, we ought not be surprised when our workplaces and other cultural institutions treat dependent human beings that way too. If pregnancy continues to be likened to any other lifestyle choice, or worse, a disability in a Hobbesian contest with wombless men, pregnant women and caregiving parents will never receive the cultural support they need. And so if the feminist revolution has stalled, as some claim it has, elevating women's workplace without elevating women in the workplace without simultaneously elevating the culturally essential work that mothers and fathers do in the home, then I believe that constitutionalizing the right to abortion shares a good deal of the blame. Now, it would surely be difficult, and here I'm really concluding, for an older generation of feminists to imagine a women's movement without Roe and Casey. These feminists remember a time when women were regarded as designed solely for domestic life, when women's opinions were undervalued, and when mothers were seen as more capable and essential to their children's upbringings than were fathers. For these older feminists, restrictions on abortion betray precisely that vision of women, one which unfairly confines women solely to maternity with no respect for their contributions beyond. This 1970s feminist fear is what the Casey plurality seems to be responding to. But for those of us who grew up with the Ginsburg gains of the 1970s securely in place, there's no question that women are as capable of educational and professional achievement as men. The questions have now become why the essential work of caring for dependents, still undertaken disproportionately by women, is not as esteemed and accommodated as it should be, and why poor women continue to be bereft of the paternal support both they and their children so heartily need. It seems to me that these are the questions a renewed women's movement must work to address, and rethinking our reliance on abortion would be a good place to start. And before I take myself off of the screen share, I'm going to just share with you the cover of my book, where I get into a lot more of the legal history, constitutional law, and sort of philosophical arguments.